Really announced saying that Tuesday also.
Okay, sir.
Yesterday, sir, the classes civil proceeding, how to prepare the initial exams. So, sir, now we civil procedures are completed. Now, criminal side, sir, will explain.
Suppose like complete positions in the CR cases are. We will start criminal proceedings on Tuesday.
Now, civil proceedings.
Your civil procedure finished your system.
Now, he is continuing the civil procedures. Okay.
Start Charan. Good afternoon to all of you. Yesterday we have completed up to order 37, that is summary suits. And today we will discuss about the injunctions as laid down in order 39. Injunctions are of four types. One is called interim injunction, another is called temporary injunction, another is called permanent injunction, and another is called mandatory injunction. The rules of procedure which governs injunctions is section 37 to 39 of the specific relief act. What do you exactly mean by interim injunction? Interim injunction means injunction only for a particular duration of time, subject to being extended from time to time. That is called interim injunction. An interim injunction is normally granted under the provisions of mic is available. So, interim injunction is normally granted under the provisions of the specific relief act. It's only for a duration of time, subject to being extended from time to time. Here, interim injunction is something like crocin when you get fever, you get some relief from that. So here, interim injunction is normally granted when you establish a prima facie case, that is a case on the face of it, balance of convenience and relative hardship. These are the three ingredients which you have to satisfy for grant of injunction. And please remember, an interim injunction is granted only for a specific duration of time, subject to being extended from time to time. Here, as far as CPC is concerned, Order 39 deals with what is called temporary injunctions alone. That means, normally, under the 1976 code, it is said injunction should not be granted immediately without hearing the other side. That is the reason why courts pass what is called status quo orders. That is, things stand where they are. But unfortunately, status quo is not defined anywhere. Status quo is interpreted in a different way. I just remember Justice Subhashan Reddy used to comment in the High Court, sir, it is something like a Koja order. Neither it is a man or a female, a man or a woman. It's a third sex. Either you allow the application or dismiss an application. Where is the question of passing a status quo order? But unfortunately, what is happening is, in most of the courts, they hear you everything, hear you in detail, and ultimately, sir, you please go away, we'll pass orders. Ultimately, we see urgent notice is ordered to the other side. And if you still press, status quo orders are normally passed. And status quo gives rise to different interpretations. According to status quo means something else. According to me, status quo means something else. That means things stand where they are. Neither you can do anything nor other side can do anything. That is what status quo means. But three ingredients to satisfy a grant of injunction is what is called prima facie case, balance of convenience, and relative hardship. So if these three ingredients are satisfied, injunction can be granted. And one thing is this, temporary injunction can be granted only when both the sides are heard and both the sides file their counter and the matter is heard threadbare. And a temporary injunction which is granted under Order 39, Rule 1, subsists till the disposal of the suit. That means the other side cannot interfere with your position or what you have asked. So the question is, temporary injunction is till the culmination of the suit, and temporary injunction is normally granted on merits. That is, when the other side files the counter based on the petition and based on the counter, based on the facts and based on the documents, and based on the arguments and case law which has been advanced by both the sides, a temporary injunction is granted. Then the question arises, can a temporary injunction be granted by the appellate court? The question is, first and foremost, you must remember is, appeal is supposed to be a continuation of the suit. Whatever applies to the lower court also applies to the appellate court. Even the appellate court is competent to issue an injunction order. Then there is a procedure that you have to follow under Order 39, Rule 3. You are supposed to send the documents and send the copy of the petition and the material papers to the opposite side and file an affidavit in compliance of Order 39, Rule 3 along with the postal receipt. Unless you file the affidavit of compliance and the postal receipt, the injunction will not be communicated to the other side. Then suppose the injunction order is disobeyed or there is a disobedience, then in that particular case, you can always file a petition for punishing the opposite side for disobedience. That is Order 39, Rule 2A. Then you have got various procedures. That is, you can ask for vacating the injunction order or for making the injunction absolute and all. Suppose you are able to satisfy the court, you have got a meritorious case on facts and law, then the court converts the interim injunction into a temporary injunction. It subsists till the disposal of the suit. Because please remember, because of paucity of time, I cannot go in a lengthy manner. Then you have got one more thing called mandatory injunction. The word mandatory injunction is not covered by CPC, but it is governed by Section 39 of the Specific Relief Act, which says mandatory means it comes from the word mandate. Mandate means command, or command means order, and ask the other side to do what he has not done. That is what is called mandatory injunction. And the same principles apply as far as mandatory injunction is concerned. And once the suit is disposed of, after hearing arguments and the evidence, etc., the injunction which is already granted becomes absolute. And then we say that petition is allowed. Suppose the court is not inclined to grant you an injunction, then the court vacates the injunction which is already granted. But please remember, you have always got a right of appeal under Section 104, read with Order 43 CPC. That is appeals against miscellaneous orders. So appeals against interlocutory applications, an appeal lies under 104, read with Order 43 Civil Procedure Code, provided your case comes under any of the clauses mentioned in Order 43. Then in that case, you can file a miscellaneous appeal. It is normally numbered as CMA, Civil Miscellaneous Appeal. Then once the appeal is filed, the court calls for the records from the lower court, and after hearing both the sides, it has got the power of either confirming, setting aside, modifying, or varying the orders of the lower court. That is the appellate court's powers as far as Order 43 is concerned. Then the question arises, once the parties go into the witness box, their evidence is recorded, arguments are heard, and then the court gives its final verdict or judgment, and that is what is called the temporary injunction becomes a permanent injunction or perpetual injunction. Then we go to Order 38, Order 38 Civil Procedure Code, that discusses about attachment before judgment and arrest before judgment. Here, if the defendant is about to abscond from the jurisdiction of the court, or is trying to alienate or secrete the property, and the plaintiff will not be left with any security against which he can proceed in case the suit goes on and ultimately succeeds, That is the reason, even before a judgment is passed, the court can pass an order for attachment either of movable property or immovable property. But please remember, after the Civil Procedure Code was amended in 1976, where they said an absolute injunction, an absolute attachment cannot be ordered. Other side, a conditional attachment only can be passed. That is, the other side is given an opportunity of furnishing security for the suit amount with cost or third party security, saying that in case a decree is passed, the decree will be obeyed and complied with. That is the reason a conditional attachment is ordered, and 2 or 3 days is given for the defendant to comply with the order and then to furnish security. If he does not do it, the movable property or immovable property owned and possessed by the opposite side will be attached before judgment. What do you mean by exactly by the word attachment? Attachment means where there's a prohibitory order not to alienate the property, not to encumber the property, not to charge the property, and to say that particular property, be it movables or immovables, is subject to the charge of the court as far as that suit is concerned. That is the reason Order 38 clearly says that an attachment cannot be ordered as a matter of course. Other side also should be given an opportunity of being heard and to furnish security for the suit claim. And you have to satisfy that the other side is running away from the jurisdiction of the court or is trying to secrete his movable and immovable property, and the decree or the plaintiff will not be left with any security against which he can proceed, even assuming without admitting that a decree is passed. In exceptional cases only, attachment is normally ordered. And arrest before judgment, though it is in the statute book, arrest is not normally granted. Arrest cannot be ordered because you have got the leading case of Varghese versus Bank of Cochin, reported in AR 1980 Supreme Court 470, which says to hold the person of the judgment debtor in prison or arrest him in civil detention amounts to satisfying the Machiavellian designs of a modern Shylock who wants to have his pound of flesh. And in this particular case, the Supreme Court Justice V.R. Krishna here said, even though the judgment debtor or the defendant had means earlier, but he has no means today to pay the decretal debt or the amount which is to be granted, then in that case, arrest cannot be ordered. So, without issuing notice to the judgment debtor or notice to the defendant, arrest cannot be ordered. And the judgment debtor or the defendant has to be heard before an arrest can be made. And that is the reason why courts are very, very reluctant to grant arrest before judgment. Though it is in the statute book, please remember it is not followed or it's not complied with. That is what Order 38 speaks about. Then Order 39 I have already completed. Order 40 you can delete. That is appointment of receivers to safeguard the property. That is, an administrator is appointed or an advocate receiver is appointed to take charge of the movable property or immovable property, administer the property, collect the rents, collect the profits, and then deposit the rents or the profits from time to time to the credit of the suit. That is what is called receiver. What are the conditions in which receiver is appointed is when the property is wasted, when the property is misused, when the amount which is due and payable to the plaintiff is not paid, or when there is no scope of executing the decree, even if passed, then an administrator or a court officer, normally in the panel of receiver, is appointed to collect the rents, collect the profit, and then deposit it from time to time. Then we come to Order 41, that is appeals against regular decrees. That is what you call as a regular first appeal. Here, as far as first appeal is concerned, it is available to you as a matter of right. No one can stop you from filing an appeal. But what are the papers you file along with the appeal is, you file the memo of grounds, you file the copy of the decree and judgment which is appealed against, and then the person who files the appeal is called the appellant, and the person against whom the appeal is filed is called the respondent. And the nature of the proceeding is numbered as AS. AS means appeal suit. AS means appeal suit. And this is filed under the provisions of Section 96, read with Order 41, Rule 1 CPC. Section 96, read with Order 41, Rule 1 CPC. What are the matters you will have to state in the memo of grounds. There is no hard and fast rule what you can state. Normally, when we write the appeal, we say the third paragraph is a being agreed by the judgment and decree in OS number so and so, dated so and so, or on the file of the so and so. The appellant begs to file this appeal on the following among other grounds. And normally, different people have got different ways of drafting. Normally, what we do is brief facts of the case we write first, and then after that we come to the grounds on which you are aggrieved. Normally, what are the grounds you can conceive, sir? One is admissions, contradictions, inconsistencies, or the case law which has been misappreciated by the lower court, that you can bring it to the notice of the appellate court and say, sir, these are the mistakes committed by the lower court. Please set it aside and allow the appeal. Here I could say, yes, I'll tell. Here, first ground will say the judgment and decree of the lower court is against the law, materials and evidence on record. Number two, the lower court erred in passing the judgment on surmises and conjectures of its own imagination. Third one is the lower court has not appreciated the various exhibits that have been filed by the plaintiff and the admissions and inconsistencies and contradictions in the evidence of the opposite side. Here, sometimes please remember, that's what it is jocularly remarked, that the appellate court is like a mother-in-law and the lower court is like a daughter-in-law. When normally, the enmity or the rivalry between a mother-in-law and the daughter-in-law. Because the mother-in-law has suffered in the hands of her mother-in-law, the mother-in-law tries to take revenge on her daughter-in-law. And whatever the daughter-in-law does or says is always she tries to find fault. And that is the reason when the daughter-in-law commits mistake, the mother-in-law should correct her. So that is the reason the appellate court is supposed to be like a mother-in-law. But unfortunately, what is happening is the appellate court is not adverting its mind as far as the vis-a-vis the judgment of the lower court. Easiest form of writing a judgment is confirm the judgment of the lower court. Here, I think in computer language you say cut and paste. The stenographer is instructed, sir, please copy the judgment of the lower court. Leave the last paragraph to me. Here, the last paragraph will be strenuous arguments have been urged by the counsel for the appellant, but I do not find any reason to interfere with the judgment and decree of the lower court, and the judgment and decree of the lower court is hereby confirmed. I could put it in a lighter way. Operation successful, but patient died. Please remember, the appellate court, there are judges who say, of course, I am not remarking against any judge, but the appellate court judge says, sir, it's easy to confirm a judgment rather than dissenting from a judgment. Why? Because if you want to dissent, then you will have to burn your midnight oil and rack your brains and then write a judgment and reversing the lower court judgment. Here, of course, in my early days of practice, we had an judge by name Krishnamurthy in the City Civil Court, Hyderabad. Please remember, any good case which has been decreed by the lower court, he used to reverse it in appeal. He was called the reversal judge. And whenever we wanted to succeed in an appeal, we used to get it posted before him. Why? Because he was used to act strictly like a mother-in-law. And he used to find fault with the lower court and say, these are all the mistakes committed by the lower court. But are we having such judges today? Unfortunately, we are having judges who are adopting the cut and paste policy. But I definitely say, once the appeal is filed, what is the duty of the appellate court? The appellate court has to issue notice to the opposite side, and the opposite side appears. Then the appellate court has to call for the records of the lower court, and then after the records come, both the advocate for the appellant as well as the respondent argue the appeal, and then the judge passes a judgment vis-a-vis the facts of the case and what has been urged. And the appellate court has got the power either to confirm, set aside, vary, or modify the judgment of the lower court. Yeah. So So the appellate court has got the power either to confirm, set aside, modify, or vary the judgment and decree of the lower court, and these are the powers which are granted to the appellate court under the Code of Civil Procedure. Then one more thing you must remember that as far as suppose let us say an appeal has been dismissed for default because of your non-appearance on the particular day. Please remember you need not dispatch, but there is a provision called Order 41, Rule 19 CPC. Order 41, Rule 19 CPC, which provides for re-hearing of the appeal. The mic was there. There's a fault in the mic. Order 41, Rule 19 says, whenever an appeal has been disposed of on, let us say it has been dismissed for default, then in that case, you can file an application accompanied by an affidavit under the provisions of Order 41, Rule 19, which speaks about re-hearing of the appeal. Order 41, Rule 19 speaks about re-hearing of the appeal. Order 41, Rule 19. Kindly make a note of it, please. Then you have got one more provision, Order 41, Rule 27, which says a petition for additional evidence. That is some document which has come to your knowledge later or which has not been looked into by the lower court. Then you can file a petition under Order 41, Rule 27 for needing additional evidence. This is as far as the appellate procedure is concerned. Then we go to Order 41, Rule 27. Then we come to revisions, which are normally filed in the High Court. Revisions, the District Court has got no power. It is only the High Court which has got the power under Article 227 of the Constitution, whereby being aggrieved by the judgment and decree, either in a CMA or any interlocutory application, a revision can be filed before the High Court. That is under Article 227 of the Constitution. Then, when is a revision filed, sir? When there is an error apparent on the face of record, or there is a miscarriage of justice, or when the lower court has misapprehended itself on the facts of the case. Mic
down the
I will go on without mic. I don't require the mic also.
Okay.
Because my voice is too
Your
loud.
voice itself is a mic.
So, as far as revision is concerned, whenever an order is passed in an interlocutory application where there is a miscarriage of justice, the lower court has committed mistakes, there is a latent or patent error or exercise of jurisdiction which is not vested with the court, or non-exercise of jurisdiction though vested with the court, or there is an error, latent or patent, which is apparent on the face of the record. In those three circumstances, a revision can be filed under the provisions of Order 45, read with Article 226 of the Constitution or 227 of the Constitution. Yeah. Then we go to the next procedure called review. What do you mean by review? Please remember, we pronounce it as review, but it's not exactly review. It means review. That is, you have committed these mistakes, you have committed this latent or patent mistakes. Please have a relook at the matter and then consider the matter again. That is what is called review, not review. It is, though it is spelled as review, it is pronounced as review. That is, have a fresh look at the matter. When there is an error apparent on the face of the record, when the court has not looked into the various contradictions, admissions, and inconsistencies as far as the case is concerned, and in that case, review lies to the same court which passed the judgment and decree. That is Order 47, read with Section 114 of the Civil Procedure Code. Then we come to the last order, which is not normally followed, reference. What do you mean by reference? Reference means where there is a point of law which is involved in a particular case, and there are inconsistent judgments of the various courts, and the court is not able to decide as to how to decide the matter. Then in that case, it prepares a questionnaire and refers it to the High Court, and the High Court will have to answer every question that is raised, and then according to the answers that are given by the High Court in reference, the matter is decided. Please remember, in reference, parties don't participate. It is only the lower court judge and the High Court judge. That is, questions are raised, questions are formulated, and it is sent to the High Court to give the answers as far as the questions are concerned. And according to the answers, clarifications given by the High Court, the matter is decided accordingly. That is what is called reference. So this is as far as the orders are concerned. Then there are certain sections which do not find its place in the orders. That is, first one is restitution. Suppose the judgment and decree of the lower court is set aside. Then in appeal, you succeed in the appeal. You have lost possession of the property. The court can put you back into possession of the property because you have succeeded there. And even though you have lost possession, the court will direct the opposite side to restore possession back to you. That is what is called restitution. That is 144. Then we come to 89. 89 is a new section that has been incorporated where they refer to alternate disputes redressal, ADRs as they call it. That is, disputes being settled by the Lok Adalat, third party mediation, or by arbitration, or by any other mode. And please remember, once the written statement is filed, the court first posts it for 89 settlement. That means it inquires from both the parties whether the matter can be settled across the table instead of going for a trial. That is what is called section 89. 89 is nothing but ADR. ADR means alternate disputes redressal. But the advantage of going through section 89 is whatever court fees you have paid, whatever court fees you have paid, court directs, addresses a letter to the collector to refund the court fee. So you get refund of the court fee in case the matter is decided across the table without a trial. That is what section 89 inquiry takes place. Then we go to the important provision that is executions. Then you have got the Zinda Tilisman, that is 151. You use everything. If you do not know anything, write section 151. But please remember, unfortunately, we are having courts which says, you have got a provision, why do you write 151? If an advocate like me appears before the court, sir, don't you know the provision? You substitute the provision. Because there is a judgment of our High Court which says, courts are not operating trapdoors to catch the unwary. Even I mention a wrong provision of law, the court can interpret it by incorporating the correct provision of law and then write it. Court cannot say, please throw it out and say you have written 151. There is a regular provision. But please remember, court does not know anything. Your section makes that endorsement. You will have to satisfy the court. But if you do not know a provision, then resort to 151. That is inherent powers of the court. Corresponding provision in your CRPC is 482. Please remember, 482 is inherent powers of a criminal court. But please remember, your lower courts have no power under 482. It's only the High Court which has got the power under 482. 482 cannot be exercised by a magistrate. It cannot be exercised by an ACM. It cannot be exercised by a metropolitan session judge. Only the High Court has got the power under 482 CRPC. But here, 151, please remember, we see most of the juniors, what they do is if they do not know the provision, they'll write 151. But please please read the book. You have not read the book when you were in the college, at least read it now. So 151 speaks about inherent powers of the court. Then you have got 152. Whenever there is an arithmetical error, clerical error in the decree or the judgment, you can always file an application under 152, ask the court to correct it. Then 153 says at any time, even after the decree, you can file such an application. Such an application is made. Then section 60 I have already referred to yesterday. Then we come to the latest amendments to the Civil Procedure Code. That is, amendments which have taken place after Act 22 of 2002, effective from 1/7/2002, was passed, whereby we have got 24 to 26 amendments. First amendment which we can think of is Order 5. What does Order 5 deal with, sir? Issues. Here, issues, summons. As far as summons are concerned, most of the delays which occur in court is because of non-service of summons. So, what they did in 2002 is they amended Order 5 and provided for extra modes of service of summons. You can send it by EMS, you can send it by WhatsApp, you can send it by speed post, you can send it by courier or any other mode. It is proper service under the law. Order 5. Then the second amendment which has been brought is Order 6, Rule 1, where they say all plaints in the civil court has to be filed in duplicate. You know why it is? Why they ask you to file it in duplicate? Because the judge, when he makes notes, he will try to highlight the duplicate copy and not the original copy. And then one more copy you are also supposed to file. That is what is called computer copy. Because nowadays things have become so easy and people have become lazy. When you file the computer copy, it is supposed to be scanned in the computer, and then this extra copy which you give is stuck to a register called the suit register. In the suit register, it is stuck. And whenever you want a certified copy from the suit register, they take it out and give you a certified copy of the plaint or whatever it is. Then the next amendment which has come is you have got Order 6, Rule 17. Order 6, Rule 17 was a merry-go-round for many advocates like you and me. Why? Because the previous judgments, if you see the reported judgment, you can carry out amendment even up to the stage of second appeal. But now, Order 6, Rule 17, bracket 2 has been introduced, whereby they say once issues are framed and evidence affidavits are filed into the court in exceptional cases alone has to allow amendment, not otherwise. Order 6, Rule 17, bracket 2. Then another amendment which has come is Order 14. In issues, they have introduced a new rule called Order 14, Rule 5, where they say if scandalous, vexatious, defamatory, or damaging allegations are made in the pleadings, the court can order the pleadings to be removed and expunged. That is what is called vexatious, scandalous, and defamatory allegations made. The court can ask the advocate concerned, please withdraw those allegations. That is a new amendment which has come in Order 14. Then we come to the other amendment, Order 18. Yesterday itself I dealt with it to say some of us are good in writing and some of us are good only in talking. So the reason is, suppose we don't have the oratory power because of stage fear or because of lack of vocabulary or lack of expression. In that case, Order 18, Rule 2, bracket 3 says written arguments can be filed into the court, and after the culmination of the argument, within 7 days, it has to be filed. And once you file the written argument, court can also say, sir, I'm giving you half an hour's time or 1 hour time, please try to finish your arguments. Court can also save its time. But once the written arguments are filed, the opposite side also gets 7 days time. Looking at your written arguments, they can also argue the matter and then also file the written arguments. One advantage of filing written arguments before the court is, sometimes Anta Ramayana Vedese Ramru Sita Emaindan Adigara. So sometimes you see some of the judgments, it is like that. So that is, and most of the judges don't make note of your arguments. You must have noticed laws. They'll be only watching like this. God only knows whether they are seeing a movie or a TV serial. But here, to avoid the courts being lazy, courts being negligent, courts were trying to mete out justice to a party, written arguments provision has been provided under Order 18, Rule 2, bracket 3. Correspondingly, in our criminal law, you've got a provision, I think most of you know, 314 CRPC, which says written arguments can be filed before the criminal court. If you do not have the capacity to argue a matter, or you have got a stage fear, better put it in writing and then file it before the court. So same thing in civil procedure also, provision has been made for filing written arguments. Then one more drastic amendment which has come in the civil procedure code is Order 18, Rule 4 and 5. I think most of you are aware of this. That is, all evidences in chief shall be filed by an affidavit. Evidence affidavit has to be filed. And as far as the documents are concerned, the court itself marks the document, and the court itself can record the cross-examination or delegate the matter to an advocate commissioner. But please remember, when these amendments came, I went on record by publishing an article, the Pandora's box of commotion has been raised in civil matters. Why? Because courts abdicate their duty in recording the evidence. The only useful thing they do is to record the evidence. I still remember when I started practice in 72, judges were writing pages and pages of depositions till 5 o'clock. But now everything has become easy. You appoint a commissioner. Commissioner records the cross-examination. Like what is called అంటే అన్నమంత కలిపి పప్పు కలిపి నెయ్యి వేసి మా నోట్లో పెడతారు అది అట్లా అయిపోయింది. The question is the difficulty of a commissioner. I'm not against junior advocates, please. Like the problem of when a junior advocate is appointed as a commissioner is unfortunately they are not equipped with the rules of procedure. And please remember, there is no seriousness when the the cross-examination is conducted before the commissioner. Please remember, ఇప్పుడే పాన్ తినేసి వస్తాను బయట పోతాను, ఇప్పుడే సిగరెట్ తాగేసి వస్తాను బయటకు పోతాను, దెన్ ఇప్పుడే లంచ్ చేసేస్తాను 1 hour తర్వాత the commissioner has to wait till such time the advocate lands up. And please remember, no, I've not seen any advocate cooperating with the commissioner. So, for example, suppose they say, commission 20 తారీఖు పెడతానండి 12కి పెడతాను మీకు ఏది కను 20 అంటే 20 రోజు 20 తారీఖు కాదండి 27కి పెట్టండి 27కి అదే సమాధానం. It goes on getting urgent. If one side is ready, the other side will not be ready. And one thing you must remember, commissioner cannot know the demeanor or the mannerism of a witness, which the court can do. Please remember, it's not that easy to come and give evidence in court. Once you come and give evidence in court, that fear will always be there. But that seriousness is not there when you appear before the commissioner. That is one. Then second thing is, the commissioner is not equipped with the knowledge of the Evidence Act. There are two things called suit documents and evidentiary documents. What do you mean by suit documents? Suit documents means the foundation of the claim or the foundation of the claim is support and substantiate the allegations which you have made in the plea. What do you mean by evidentiary documents? Evidentiary documents mean documents wherein you have admissions, where you have contradictions, inconsistencies, which is contra to what you have stated in your written statement or whatever it is. So evidentiary documents, please bear it in mind, is a privilege of a cross-examiner to confront this document at the time of cross-examination. They need not be filed along with the suit. But when you appear before a commissioner, the simple question is, she will say, please file it in court with the documents which then I'll record. Please remember, a commissioner cannot say so. So that is the reason in some of the cases where where you try to encounter problems, it is better to conduct the cross-examination in court itself instead of before a commissioner. Then we have got what is called Order 20. Order 20 speaks about what is the time within which a judgment has to be passed. Under the old code, the judgment has to be passed immediately or within 14 days. But they found that the courts are very, very busy. They got a lot of work. If you see the courts, they don't do any work except sit in the chair. Then I don't know what they're dreaming about their husbands or children. So the question is, here no seriousness is there. But in the High Court, if you see, the judgment is passed immediately. The judge knows it. He reads the file and comes to the court. But normally, in heavy matters, court do not pass the judgment immediately. And please remember, they take 14 days time. That was the old code. Within 14 days, at any time, the judgment can be passed. But now the provision has been amended, whereby they say within 30 days, at any time, the judgment can be pronounced, provided notice is given to both the sides at the time of pronouncement of the judgment, and then it is prominently exhibited on the notice board of the court. In this, I just want to tell you one thing in a humorous way, because we can't go with the subject flow, because it will be boring. Here, there was one senior advocate by name Sultan Abdul Wahid Owaisi, who was the founder of the MIM party, the father of Salahuddin Owaisi. A particular junior like you, like Shavanti and all, was asked to take a judgment by our senior, and normally judgments are pronounced at 4 o'clock or 4:30. Then the party was a Muslim, the advocate also was a Muslim, and then he appeared before the court and prostrated, Hyderabad principle. Both the party and the council were saluting the judge. Then the judge said, the suit of the plaintiff is hereby dismissed. Then the party got a bit apprehensive and said, हमारा मुकदमा क्या हुआ साहब? अरे ये नाजिम साहब अपना मुकदमा खारिज कर दिए. That is dismissed our suit. Then this Abdul Owaisi called him aside and said, Barkurdar, what is your experience in the profession? This man said, sir, I have only 3 months of experience. Then he said, sir, don't bother because your senior knew that the case is going to go against him. That is the reason why he sent you to take the judgment. Don't tell your client that the case has been dismissed. Tell your client, after all, it's only a junior civil judge who has passed the judgment. He has not understood our case. Your case is so complicated. It has not entered his brain. Then suppose I file an appeal. In Urdu, they call it as Murafa. If I file an appeal, suppose the appellate court also goes against me, what should I do? Then he said, prostrate before the judge. Both you and your client, prostrate before the salam kijiye. Then the judge was embarrassed. He said, I've written a judgment against you. Why are you saluting me? He said, sir, I'm very happy that you are allowing me to see the High Court to file an appeal there. Then suppose the High Court also goes against me, what should I do? Then he said, Salam Mandijiye, or say that I'm thankful to you, sir, because you have given me permission to see Qutub Minar. Then suppose Qutub Minar bhi mere khilaf gaya to kya karna? Then दोनों हाथा पैदा के अल्लाह से दुआ मांग. So that is how you keep your client with you. So this is all the court craft. This comes by mostly by experience. That is, you tell your client that there is some hope in the horizon where you can succeed in the appellate court, because all of us live on hopes. But please don't be carried away by that. Appellate court is so bad, High Court is so bad, Supreme Court also is so bad. It only depends upon आपके मौकिल का नसीब. Whatever is there. Sometimes the worst of cases you succeed, the best of cases you lose. It depends on so many factors. And then your what is called even appeals when you file a regular appeal or a CMA, you are supposed to file the grounds of appeal in duplicate. Here also the same procedure is followed. I think in family court also they are insisting on duplicate copies. The next amendment which was there is Order 6, Rule 15, bracket 4. That is what is called verification affidavit. Verification affidavit has to be filed. What do you mean by verification of affidavit? That is, in criminal jurisprudence, when a death sentence is passed, what the judge should say is, and until he is dead. In one case, what happened was a particular accused, death sentence was passed against him. The noose was put on the neck, but the noose came out. Noose did not fit his neck, and then they wanted to put the noose again. Then what the court said was, you can only hang a person only once. You cannot hang him again. So they said, they amended that. They said, hang until he is dead. That means, marne tak aapko receipt dal dijiye. So this is how things go on. Here, as far as Order 6 Rule 15.4 is concerned, it only protects an advocate. Why? Because please remember, at inconvenient positions, your client will say, "Aap ye likhe kya? Did you give these instructions to your client, to your advocate?" No, sir, I do not know anything. My advocate only wrote it. My advocate only knows. Please remember, an advocate knows the legal position. But as far as the facts are concerned, instructions are given to you by the party at the time you draft a paper. But please remember, your client will let you down somewhere or the other. That is the reason, especially when defamatory allegations are made in the plain, according to the instructions of the client, take the signature of the client and file the verification affidavit so that the court can come to the conclusion that the pleadings are prepared according to the dictates of the party and not by yourself. Then we go to Order 6 Rule 14. This is also being insisted by courts today. That is where you say you file an affidavit into the court and say the name, address, and description of the plaintiff, name, address, and description of the defendant. The addresses given above is true and correct, and the party signs it and files. And then, along with the suit for immobile property, you are also supposed to file Form 8. Form 8 is nothing but valuation of the property. Then, of course, Bata, Gita, and all that, that's a different matter. Then we come to the next amendment that is laid down is as far as as far as Order 20 is concerned, what are the papers you file along with the appeal, sir? You are also supposed to file the judgment, and you are also supposed to file the decree. But sometimes what happens is the court takes its own time in preparing the decree. You can file the appeal even without the decree and ask for dispensing with filing the copy of the decree and give an undertaking. I will file it later as and when I obtain the copy. Then in that case, the court can number your appeal and hear your appeal. But suppose 3 or 4 cases are clubbed together and a common judgment is passed and a common decree is passed, you can file the decree in only one appeal. You need not file in another suit. These are all the amendments which have come. And 148 and 149. Please remember, whenever the court orders for payment of process, payment of bata as it is called, 3 days time is given to you to deposit the process. You don't deposit it within 3 days. Within that, the maximum time within which you must pay the process is 30 days with a delay petition. So these are some of the amendments, please, as far as the CPC is concerned. They are not exhaustive, but they are brief. So as far as CPC is concerned, it is deemed to have been completed. Of course, I am not saying exhaustive, but brief, in brief. And some of you are interested to have a detailed study of that. I've already beamed it in the Zoom, where most of you have got the link. You can kindly go through my lectures. I'm not saying I'm not advertising for my lectures, but you can go through it. And here, because of the paucity of time, I'm going it in a brief manner. And as far as your criminal law is concerned, we will try to go through it on Tuesday. That is, if I think if your committee permits me to do it, I'll do it. Tuesday. One minute. People who are appearing for the JCJ examination, it's a three-way. One is the objective type, another is essay type, and third one is viva. As far as the objective type is concerned, it comprises of questions in the form of fill up the blanks, and multiple choices are given. You are supposed to choose the correct answer and then write it accordingly. Then, as far as the essay type is concerned, you are supposed to write it in detail. But here, please remember your JCJ examination. Don't think that only CPC questions will be asked. Even the questions can be asked on your Negotiable Instruments Act also. And questions can be asked on the Easements Act. Questions are normally asked on the Excise Act also nowadays. And questions are also asked on Specific Relief Act, then Contracts Act, then Companies Act they don't ask because they don't expect a JCJ to know the company law. Then Partnership Act, Sale of Goods Act, then so on and so forth. So question is in the objective type, you are supposed to write yes or no or fill up the blanks. That is, for example, I tell you, cause of action means, then dash. That means bundle of facts and bundle of facts and documents put together is what is called a cause of action. Or the causes which gives rise to an action in a court of law is what is called cause of action. Based on facts and documents. That is what is called cause of action. Then what do you mean by jurisdiction? Jurisdiction, pecuniary jurisdiction means dash. Pecuniary jurisdiction means according to the money value of the suit, the authority of the court is fixed. Then what is the hierarchy of courts as far as civil matters are concerned is, it is a three-tier compartment. First you have got the district judge, below the district judge you have got the sub-judges or senior civil judges, and below the senior civil judges you have got the junior civil judge. And above all of them you have got the high court, that is supposed to be the apex court as far as the state is concerned. Then you know what you mean by pecuniary jurisdiction is money value is fixed. Today, what can you tell me? What is the money value as far as junior civil judge is concerned? According to the latest amendment, till 20 lakhs, a junior civil judge has got power, and above 20 lakhs to 50 lakhs, it is a senior civil judge, and above 50 lakhs, unlimited, it is a district court. Can you tell me why this amendment has come? This amendment has come because High Court wants to wash off its hands as far as first appeals are concerned. At the grassroots level itself, matters should be trashed out. Matters should be settled. That's the reason High Court does not want to entertain any first appeals. Here, pecuniary means according to the money value. Territorial means where the cause of action is approved, where it has arisen, that particular place will have the jurisdiction to try that particular matter. Third one is subject matter jurisdiction. What do you mean by subject matter jurisdiction? That means now special tribunals are constituted. You've got the family court which can decide matters at the Hindu Marriage Act, Special Marriage Act, Christian Marriage Act, Indian Divorce Act, so on and so forth. And all matters concerning a family, a dispute between the husband and wife can be decided only by the family court, and a civil court has no jurisdiction. In this regard, I try to cite section 9 of Civil Procedure Code, which says all matters of civil nature can be filed in a civil court unless expressly barred. Unless expressly barred. That is what section 9 says. Then we have got section 11. The examiner has got a fancy for section 11. Res judicata. Res judicata. Res judicata means res means thing. Judicata means adjudicated. That is, you cannot beat a dead horse and make it alive. You are not such a Sai Baba or someone to make dead persons alive. So law says that it is based on two maxims: interest the publicae, esse finilitum. Interest of the state to finish the litigation at some stage or the other. Don't go on with endless litigation. Second one is nemo deve pis vexari pro uni et adem causa. That is, don't trouble a person for the same cause over again. These are the two maxims on which res judicata is based. I go step by step. That is where a right to property is directly and substantially an issue. Again, I repeat, where a right to property is directly and substantially an issue between the same parties litigating under the same title, filed in a competent court, which is heard and decided, it cannot be reopened again. That is res judicata. That means where a right to property is directly and substantially an issue and between the same parties and litigating under the same title and filed in a competent court of competent jurisdiction, it has been heard and decided, it cannot be reopened again. That is what is called res judicata. Then we go to section 11(4), which says it is called constructive res judicata. What do you mean? All grounds of attack and defense which might or ought to have been taken, if not taken, is deemed to be waived. That means whatever defenses you have got, whatever grounds you have got for attacking the other side, you have to raise it in the same pleadings. If you don't do it, later on you cannot do it. That's what it's called constructive res judicata. Then one more aspect which is normally dealt with by the examiner is estoppel. Estoppel, that is 114 and 115 of the Evidence Act, which says estoppel in pay and estoppel by record. Estoppel in pay means whereby words, conduct, implication, you make a representation, and the other side bases his stand on your averments and changes his position, which you would not have done but for your representation. The law compels you not to make any other representation contrary to what you have made, and that is what is, your mouth is shut. You cannot make a different representation than what you have already made. That means, please remember, it's only a prerogative of a politician. He says something today, tomorrow he'll say, sir, I've been misquoted. This is the correct position. But in law, it says, if you make a particular representation and the other side acts on your representation, changes his position, which you would not have done but for your representation, you will be compelled to make good that representation. That is what is called estoppel in pay, P-A-I-S. That is 114. 115 is estoppel by record. I told you same res judicata. Where a matter has been heard and disposed of, you cannot file a fresh suit in respect of the same claim in the same court. That is what is called estoppel by record. Then again you have got estoppel in various laws, like even in Transfer of Property Act, you have got estoppel by possession. That is, you cannot deny the title of your landlord, and if you deny the title of your landlord, straight away eviction can be ordered without going into the other grounds. That is 109 of the Transfer of Property Act. Of course, I cannot go more exhaustively. I try to cover as many aspects as possible in civil law within these 2 days, and we'll have a lecture on criminal law on Tuesday. Thank you very much.
Thank you. Thank you very much for the